Hume, Mr. Professor R. Venkat and Ms. Geetu Singh on dais. Mr. Alok Jain will be moderating this session. Over to you, Alok. Those who are outside of the hall, request you all to take your seat.
Can I request everyone at the back, please be seated. I have the pleasure and privilege of moderating this panel on claim quantification in construction disputes. Very quickly, I'll just give a brief introduction of our panelists. We have with us David Hume, who is a partner at AO & Sherman. We have Professor Venkat from the Manipal School. We have with us Geetu from KPMG. She's a partner at KPMG. Unfortunately, our last panelist, Mr. Chung, who is the chair of SCL Vietnam, couldn't be here because of some visa issues. But we'll dive straight into the topic. Now, the topic today is claim quantification in construction disputes. And it's very easy as a construction lawyer to say that, look, we've established liability, but what next? Because really the client wants the color of money. And that is where the quantification part comes in. And what a lot of us as lawyers, maybe not experts, Geetu, but as lawyers, often miss out on is the actual process of quantification, the heads of claim. And that's precisely how we intend to pursue this topic today, is to first look at certain important heads of claims. Obviously, we will not be able to cover all in the short time that we've been given. And with Geetu's inputs, the best practices in terms of quantification. So let me start with David, who's going to talk about prolongation cost claims. David, the term by itself is fairly controversial and it creates a lot of issues for the claimant. So what is exactly, in your view, the coverage of that term?
Thank you, Alok, and thanks once again to the SCL and the organizing committee for putting together this event. It's a real pleasure to be on this panel. I guess right at the outset, not to try and be controversial, but my view is there is no such thing as a prolongation claim. There is a claim for prolongation costs, and it's important to bear that distinction in mind always when you're trying to quantify it and establish a prolongation costs claim. You've got, first of all, your entitlement you need to establish, your causation, and then the loss, and quantify the loss with the assistance of an expert. But again, the entitlement part is essential to have clear in your head. Either there will be a contractual provision that provides for your entitlement to prolongation costs, or you will say there's been a breach of an express or an implied term in the contract that gives you this entitlement to damages. And the reason I'm kind of belaboring this point is because quite often I see as counsel, whether for the employer or for a contractor brought onto the case, that the claim for prolongation costs is essentially just all about the quantum. Someone's identified a bucket of money that they would really like to have and have given next to no thought about what is the source of entitlement and what is the origin and justification for those costs being claimed. And that's problematic and self-defeating for contractors in that position because it leads to a less efficient, less timely resolution of what might well be a justifiable claim. It takes more time to get to where they need to be. So the way I kind of think of it is you can't build a 20-story building, which is your costs claim, without a sound foundation, the entitlement. It might look good, but a gust of wind is going to knock it over and you'll be left with nothing. So in that regard then, I think the other point to bear in mind is that just because you have an entitlement to an EOT, if you can establish an entitlement to an EOT, and you've done that homework of saying, okay, well, I've got this event under the contract, gives me that entitlement. What does that get me? The EOT doesn't necessarily get you there. And that's reflected in the protocol as well. You see core principle, I think 20, that you don't get automatically prolongation costs. And there can be a number of different reasons for that. We can talk about causation being one of them and the analysis that goes into that. But also, it can be, again, the underlying entitlement event can be an issue for you. The classic example is where you have force majeure. As we saw during COVID, many contract provisions allow you extensions of time, but they don't allow you cost for a force majeure event. And so you have to recognize that. You might like, from a commercial perspective, to quantify your losses on the basis of a force majeure event, but unless you have that legal entitlement, then it's not going to be more than a commercial negotiation. It's not ultimately going to go anywhere. And you also have to bear in mind it doesn't just stop at asking who's responsible. You also need to establish you've got that contractual precondition satisfied of having given notice, having substantiated the claim, filed claim submissions within the times required under the contract, or else you risk not having any claim to make. The last point I'll make on this kind of concept of the prolongation costs claim is that employers sometimes ask, well, can I advance a claim? And there you have to look, obviously, first at, do you have a liquidated damages provision in your contract? If you do, is that going to be, under the law applicable to your contract, or even the terms of your contract, an exclusive remedy? And if so, as an employer, that's where it begins and ends. You look at your liquidated damages and that's all. The flip side of that, of course, is that sometimes contractors, in settling claims with employers, seek to modify or amend or strike out the liquidated damages clause and then continue on a live project. And that, creates a risk then for the contractor, because having deleted the liquidated damages clause, they've now created a situation where if they are late against an existing milestone, the employer's remedy is in damages and it's potentially uncapped. So again, there's a danger on the flip side where they could create an employer's ability to advance a claim for prolongation costs. So there's a danger there. Of course, the other aspect for employers or even main contractors dealing with subcontractor claims is that they may want to pass up the chain, whether there's an off-taker or there's an employer and they're the main contractor. In those situations, they're going to need to look at whether the event complained of is actually their own risk before they pass it up the chain.
In terms of, you talked about the issue of determining the essential aspects before we get to quantification. Often critical path identification is something that's considered paramount. But does the analysis end really there? Or can we head straight to quantification thereafter? Because you did talk about looking at the contractual clauses. Other things that you should be taking care of before you head straight into quantification?
Yeah, so going through those three kind of components then, if you talk about entitlement first, but then you also have causation before you get to loss. And often people kind of jump over the causation piece when they're presenting their claims, but it is important, and sometimes they jump over it because they say, well, that's a defense point for my opponent to raise, but it is worth considering up front whether you have that, whether you have issues with your claim at that stage. So again, standing back, as I mentioned, you get an EOT or you think you're entitled to an EOT, you've looked at the critical path, you see what's caused delay to the critical activities, and you say, okay, in that case, I'm going to quantify my prolongation costs against that. The legal concept is the but-for test for the remedy you're seeking. So, but for the employer's acts, would I have incurred those costs in any event? And that then leads you on to, again, the SCL protocol has principles 14 and 15. 14 talks about concurrency. That's been mentioned in the previous session, and we'll hear again in the subsequent session about that. But also you have 15, which deals with the duty to mitigate. And the classic example, or one example, would be in a situation where there's an instructed suspension, and at that point you say, well, look, should I be reallocating or demobilizing staff to minimize the prolongation related costs that I'd be suffering? So again, those are things you need to think about up front. Just as an example, in terms of the concurrency principle, and I won't get into the laws of concurrency, but a really useful example that played out in the English Technology and Construction Court was a case called Thomas Barnes related to the construction of a bus terminal in Blackburn. And it was a useful work through of how the contractor in that case, building the bus terminal, had delays to the steel structure, about 119 days of delay that were employers' fault. So they're entitled to an extension of time for that. They also sought prolongation costs for an equivalent amount of time. The court found that, get you for the EOT, you have that, but the steel structure was delaying the start of the hub finishes activity. So steel structure, hub finishes. But at the same time, for that activity, hub finishes, it also needed to have completed roof work. And the contractor's work on the roof was delayed, and it was delayed for the contractor's own fault. So you have these two activities that are being delayed at the same time, both needed for hub finishes to start. And the contractor was in delay on its roof works for about 92 days, for 92 days. So that meant that despite getting a 119-day EOT in relief from LDs, the contractor did not get its equivalent prolongation cost. It only got 27 days because, but for the employer's delay event, take that away, it would have been delayed for 92 days no matter what. Now, the contractor might say, oh, we were pacing or whatever. They'd have to have made that good, and they didn't make that good in that case. And that's a good, as I say, worked example of how that kind of issue, which is in Core Principle 14, plays out in real life, leaving aside the legal points that we'll obviously hear about as well.
Just as last question, in terms of quantification, and you have a rich experience in the Middle East as well, wanted to understand what are the repeated issues that you see in terms of quantification of these claims, especially in terms of prolongation, and how do you see tribunals react to those?
So obviously, massive qualification. Gitu and others in the room will be much more qualified than I am to say how best to evaluate, quantify prolongation costs. But in terms of my observations from what I've seen, including from how tribunals react to these things, one big one is, again, going back to the SCL, Core Principle 20 makes clear the starting point is, actual cost. And that's, not a legal principle, but more in terms of what you tend to see tribunals want to see. They want to know that, okay, you can put forward a case based on rates for whatever justification you want, but tribunals typically want to stress test that against actual cost. What is the real source of loss? If, of course, your contract specifically says that, your time-related costs, they are to be measured by reference to some kind of rate, then obviously, yes, you should present your case on that basis if it's a contractual claim. But you should also bear in mind the actual cost component, and as I say, in any event, that's going to be the default where you don't have that type of contractual provision. And so it's important to have that as a component of your case, even if you have a primary case that's built on another method. The other second point to bear in mind is that delay is not disruption, and vice versa. So where you have situations, for example, where you have task-related costs, it'd be difficult to detach from your analysis what is a time-related cost. And I'm thinking of commissioning in particular can, raise these kinds of issues. And if you've got, say, a delay event, which also happens to cause task-related resource to be on standby for a long period of time, and they are idle, then, do you start to treat them as a part of your claim for prolongation costs? I would say no. I'd say you'd still treat them as disrupted resource. They're task-related. And you analyze them by reference to the usual ways of analyzing task-related costs. But it's simply that you've identified the event that is causing them to stand by and be idle, and you have to make it good in that way, rather than trying to apply a prolongation-style analysis to those resources. But I'll be corrected if you have different views. And then the last point, and this seems to come up surprisingly often, is just to measure the costs at the time where the delay is suffered. So, during the project, not at the extended period at the end of the project or after the milestone. It's the period during which the delay is felt and suffered is when you evaluate your prolongation costs. And there's a reason for that in terms of how curves work and how resources are expended during the time of the project. And again, that's reflected in Core Principle 22 of the SCL protocol. But again, good reasons for that. And so with all of the points that I'm kind of referring to here, obviously some of these points are defense points that employers might make in response to contractor claims. But also, at the end of the day, contractors should be thinking proactively about these points, because for their own benefit, if the employer is reasonably well advised, they are points that will come back to the contractor, and either they're going to have to spend time resuscitating and revivifying their claim with good evidence and good analysis, or they're going to have to spend time thinking how they're going to explain to their own management why their claim now has to be dramatically reduced. So it's better to do these exercises up front and have a realistic picture of your position and build that into your overall strategy.
Thanks, David. I think the point that you made about often the confusion between prolongation and disruption, that segues very nicely into Professor Venkat's presentation, which is on basically disruption claims and also global claims. Can we have the presentation put up?
Okay, good evening. We have been instructed to accelerate, so we will try to finish it in the time given to us. So there are two things I'm going to talk. One is disruption. Along with that, something called global claims. Disruption is actually easy to understand as compared to delay, because we are not talking about various delay analysis, concurrency, and all those things. But it is hard to prove. This is my experience as far as the disruption is concerned. And generally, there are some legal principles and it's straightforward to look. But however, due to the lack of documentation, we find it difficult. So most of the time, the contractors try to resort to a procedure called global claims. So we will talk about that and we will take questions on that further. So that's what it is, demystifying disruption, how to prove that, measured mile analysis, then the global claims, that's what we are going to talk about it. So delay is not disruption, of course we spoke about it. Earlier we used to write delay/disruption. Now I think there is a more clarity. It's a chalk and cheese, like delay is different. So the principles are different, so we need to understand that as far as the SCL protocol is concerned, it says very clearly that disruption is related to poor efficiency. And one good thing about that is we don't have to worry about the critical path. The disruption can happen on the non-critical path also. The moment you prove that, straight away it can convert into dollars. Unlike your concurrency and other things, we don't have so many other principles to look around. Of course, you can't read it. It's very clumsy. Disruption is always clumsy. It's not easy to understand. Sometimes what happened, we start with a disruption in a non-critical path, but it could be for a longer period of time. At the end of the day, the disruption also could result in a critical delay. That's how most of the projects will start with a disruption. Then we end up into a situation where the project is disrupted as well as delayed. So this is actually not a fictitious one. We were doing a Yas Mall project in Yas Island in Abu Dhabi. So there were two car parks. One of the car park was close to that Marina circuit, the Formula 1 circuit. So where we had frequent disturbance by the employer because the race was going on, some VIP visit. So something or other, we were asked to stop the work and restart. So between the one car park which was not disrupted, the other car park which was frequently disrupted. So this is how we were calculating. I will show how that is being done. So we need to show that the impacted, the contractor was able to prove his efficiency in a non-interrupted area where what he is able to achieve. It's again, we are coming back to the measured mile. The measured mile approach can be done in two ways. One is different periods in the project where undisrupted period and disrupted period, we can compare and we can say the contractor was disrupted and the employer was responsible for the disruption. Hence, he is entitled for a compensation. Or in the same construction site, two different parts of the construction site where the works are progressing well in one area, in another area it is disrupted. So we were able to prove that there is a disruption on that. So this is where the measured mile comes into that. So no need to get into the calculators and start working it out. This is oversimplified. In reality, it will not be that straightforward where you can do your calculation with your mobile phone. I don't think it would be the case. It will be much more complicated. So we are trying to oversimplify for the sake of understanding. So again, the water lily, the famous case where anything related to delay and disruption, we can, without thinking, we can quote that particular case. So there are some legal guidance on that. the contractor have to prove that he was disrupted. But for that disruption, he would have completed the project on time, and the employer was responsible for the disruption. These are all the three things he need to prove. Having proved that, he would have a valid disruption claim. So again, there are multiple methods through which the disruption can be proven. The most commonly accepted in the international arbitration is called measured mile analysis. So that means, let's say that you are able to run a mile in maybe 10 minutes. If you are disrupted, probably if it takes 30 minutes, so if the disruption was caused by the other party, you say that I am capable of doing this in this time, now I am disrupted, so I am entitled for a compensation for that. Again, this is on a linear thing. You are trying to plot on a cumulative basis how the work was going on. In the non-disrupted period, the works were going linear. You could see that how it is tangentially going. Then there is a period of disruption where it is started getting tangential and the works are getting delayed and it's going to take a longer time. And whatever that efficiency he is losing, that would be considered as a disrupted area. This is another example. I will just run through that. So, two different periods. Maybe most of the time when the project starts, first 3 months, there may not be any disturbance. The contractor may be effectively working, efficiently working. Then after that, you will started getting change orders, which is quite common in the construction industry. So then the contractor have to start, stop, then abort the works, come back. Then he has to break something and he have to redo. So all these things started happening. Then the contractor would start building up the disruption claim. So this is how the measured mile period where there were no problem, and the disrupted period, the contractor is trying to compare. See, he is not comparing with his BOQ rates or his estimates, and he is not comparing with the industry productivity rates. He is comparing with his own productivity in a period where it was not disrupted, to a period where it is getting disrupted. So it is much more authentic, where the contractor can prove, if you don't disturb me, I am able to achieve something. Because of your disturbance, I am not able to achieve. So that's more logical to prove. So again, there is a small calculation. We don't get into that. So
Professor
it's easier to do that.
Just to sort of disrupt you over here, so as to say. But before you head into the quantification principles,
Yes, please.
there's a very fundamental issue that arises in most of these matters, is that if there's a disruption claim where there's an identifiable employer-related cause, and it overlaps with a non-employer-related cause, let's say weather, in such a case, how do you normally deal with it?
The legal guidance here is the contractor would be entitled for the period where the employer has caused the disruption. Let's say that if the contractor has mobilized a new team, there is a learning curve. The contractor could not achieve the kind of productivity on his own. So he has to carefully differentiate the inefficiency, what he has created, then only he will be able to show. The problem with the contractors is they want everything. They try to put everything as a disturbance and they try to claim. That's why most of the time the disruption claims fail. If they are smart enough, they will be able to agree that these are all the periods where there was a learning curve, there is a new team mobilized. We are not claiming for this. We are only claiming for the employer cost disruption. Then he will have a better opportunity or better way of proving that for a compensation. I guess I have answered you.
The other thing that I wanted to just check, you talked about the Lilly case, and the question over there I have is, does a contractor really need to prove that they would have made profit if it was not for the disruption? Because you talked about the costs and expenses.
Correct.
But on the profit side, does the contractor really need to prove that?
Yes, actually that is coming in the global claims. So where the judgment is, the first thing, whenever the contractor is claiming for a disruption or a global claim, what normally the tribunal or the employer will look for is, he was L1, but what was the difference between the L1 to L2? If that is 25%, he is underquoted. That means at any cost he wanted the project, so he made his own miscalculation in working out what kind of a labor hours required. So he has to prove that there was a better chance for him to make a profit, but for the disturbance caused by the owner. I think that starting point is that.
Thank you.
Yeah. So in the measured mile, there are a couple of points. we cannot take a very small area and we cannot extrapolate for a bigger project. It has to be reasonable period of time you need to consider for the disrupted and non-disrupted period, and you need to have documents. This is where we have a serious problem. I don't think the contractor may have all the delay notices and all the delay analysis, but when it comes to disruption, it is very rare to see a good amount of documents because it's very tedious. Every day putting that in their daily report, our planned productivity was so much, we achieved only this much. Normally what contractors try to do to be in the good books of the employer, they overstate the achievement. Instead of telling 100 square meter we achieved, they try to say that we did 120 square meter today. When they try to overshoot that, it becomes difficult later on to prove that we were not working efficiently, for which the disruption cost have to be paid. So my general view is wherever we were advising, we tell don't manipulate, put the real figures. Then you have a chance of coming and proving after 5 years that these are all the daily reports. We did not prepare today. These are all contemporaneous records. You could see that this period to this period, there was a huge disruption. These are all the causes, and because of which the contractor is entitled for a compensation. I'll quickly get into the global claims, another 3 minutes there, not more than that. The global claims, why it is important? Because the contractor generally, he roll it up and he try to make a claim. You will see this picture, you will see what it is. So, I'll put the whole thing. Sorry. This is how it is. The contractor says that he estimated 17 million. There was a 23 million, the final cost. And he's listing down all the things what happened. And he says that the difference between his estimate and what is the final cost, it is the loss for which the employer would be liable. This is how the global claims are made. He is telling that I am a good contractor, I am an experienced contractor, my estimates are fine, but you can come and verify, you can audit what is my final cost. The delta of that is going to be the claim you need to prove. This is not going to really work in the good old days, but there is a difference now, because there are 3 things for you to prove the claim. There was a cause and effect, there is an event happened, and there is a cause of the event for which the employer is liable, and there is a causation nexus, we call it. There is a connectivity between what is the event happened and why it happened. So this cause and effect nexus will not be proven in case of a disruption claim. So that's what it is. The third one is missing. The events are there, the money is lost, but there is no real connection between that. It is not being proven well. That's the first problem. The second problem is reverse burden of proof. What the contractor is trying to tell, I lost money, you have to pay me, you prove me wrong that if that is not the case. So I don't think any employer is going to be interested to prove that the contractor was wrong claiming for a global claim. So the third one, you are making the lump sum contract into a cost plus contract. So whatever the cost he incurred, he is trying to seek a compensation for all the money he lost. So because of these 3 problems, in the good old days, the global claims used to be outrightly rejected, but that has been changed over the time. Now there is a concession, there are legal case laws in England saying that it may be evidentially difficult for the contractor to prove a global claim, but outright rejection of the global claims may not happen. So they say that the contractor have to prove that he would have made a profit in the project, and there is a serious problem created by the owner just because the contractor was not able to individually show that cause and effect for each of the events. It will not summarily reject the contractor's global claim. That's the current legal standing on that. So for that he need to do, basically what we try to tell is, you try to break the claim into prolongation, then abortive works, then the disruption, then finally there may be a residual amount which may be could be acceptable as a global claim. But if the contractor puts everything together, including prolongation, changes, everything, then I don't think the contractor will have any opportunity to prove the global claim. So generally, I would suggest avoid as much you can, but as much as possible, if you are trying to prove that you are able to put the heads of claim, then the global claims could be still proven. It's not that contractor is lazy and he is not breaking it down. It is impossible, or it is only just an academic exercise. That kind of breakdown is not going to serve any purpose. Then the tribunals may be interested to look at your global claim. Thank you.
Thank you, sir. Geetu, turning to you, you've, I think, got 25 plus years experience as an expert witness. When you look at the tribunal and the tribunal considers your evidence, when it comes to prolongation claims, what are the critical aspects that you consider as basic for giving your expert testimony? We've heard David talk about a few of those. So could you elaborate from your, as an expert witness, what is it that you would look for?
Sure. Thank you so much, Alok. Firstly, before I commence, I promise to everybody that I will keep my responses very short, because since I'm last in the sequence on the panel, I'm definitely under a lot of time pressure.
It's very typical for experts, isn't it? All the lawyers come up to you and say, Geetu, we need this report in 15 minutes.
Absolutely. In a short period of time,
yes.
prove it, monetize for us. So, so I think you look at prolongation cost claims, and I think at the cost of repetition, I have to put that point forward that, as always, it is always a very complex web of certain factors that will go into it. No one factor in isolation can serve the purpose. Typically what happens is that unless a project has undergone some very massive variations, usually the claim monetization does take place and arise from the prolongation cost claims. Now, I will not dwell into any non-critical factors, but some of the very, very omnipresent factors which we've seen in client situations from time to time is, let's say, first of all, the very popular factor has always been the quantification of claim is driven by whether these are task-oriented claims or whether these are time-oriented claims. A construction project will primarily comprise of certain direct cost. For instance, the material cost, the labor cost, the equipment cost. A lot of these costs, which are direct costs, tend to be associated and classified together as task-oriented activities. As the term would say it, the burden of proof is extremely high when it comes to task-oriented claims, because there is an element of time, there can be an element of delay, there can be an element of disruption, it can be a concoction of all of these put together. But one, from an evidence standpoint, whether it is the technical expert or, let's say, the eventual quantifying expert who's the onus is to monetize, needs to dwell into both the elements to say that what was the delay and what was the activity which had an impact, which, let's say, led to increased material price fluctuations, maybe increased use of the equipment and increased use of labor. It could just be the quantity or the period of deployment. Let's say, for instance, in case of equipment and labor, which could be leading to additional cost claims. Then the other part comes is the time-oriented claims, which are typically, you have the site overheads, you can have the corporate overheads, you can have, let's say, insurance costs, finance costs, etc., which is, you can't associate with any sort of rhythm of an activity, whether it got delayed or disrupted. But it is a fraction of whether I would have run the project in 3 years, I would have incurred, so much of the cost, and you actually kind of prolongate it. So that typically this is one of the foremost factor which plays a huge bearing on how you tend to quantify claims. The second largest factor in my experience I've typically seen is the way you link the impact and the costs. A lot of times what happens is clients tend to come to quantification experts assuming that, our internal work is done, the lawyer is putting the legal case in place, and, a technical expert has already sort of demonstrated delays or, disruption and its impact on productivity, etc. And now in isolation, the work of a quantification claim takes place, which is actually not correct. Whether the quantifying expert is, with a business, financial, commercial background, or whether it is, let's say, someone who comes with a skill set of a quantification, a quantifying surveyor, irrespective, it is very critical that the claims that you're quantifying, whether it is task-oriented, primarily I would say task-oriented and time-oriented, there is a very logical linking and connectivity which is established. What was the impact of the delay or the disruption on the overall, let's say, the baseline project, etc., or let's say the critical path, or if one is doing the time impact analysis, whatever it may be, how has that led to the, let's say, an incremental use of resources, and how does that lead to cost? So linking between impact and cost is extremely important. Otherwise, the work product on the claim quantum expert is barely understood in the arbitration proceedings. So that's sort of there. Other than that, typically what happens is that once, let's say, you move on to how do you substantiate the cost claims. Now, at a very commonsensical level, if you have to substantiate what is the cost which has been incurred, you would have, the underlying records, which would be the invoices, the vendor contracts, etc., etc. But a lot of times, what is not understood well is that you can't do 100% authentication or verification. You have to logically resort to sampling. And I think the trickiest question which comes to any quantification expert is that what is the right, adequate amount of sampling that you need to do, which can't be 100%, but what is good, a 10% good or a 50% good, etc. I think from a case-to-case perspective, it is extremely critical that whether it is, let's say, an in-house fact witness who needs to demonstrate the reasonableness of the claim, or it is an expert witness, does not matter. At the end of the day, the testifying witness needs to take a very professional judgment sort of a call to say, what is that quantity of samples that is being tested, which will be the true representative of the entire claim. So I would say these are some of the factors, Alok, and there are many more, but I think in paucity of time, I'll just sort of curtail to that.
No, thank you. I think you talked about records, whether it is the employer or whether it's the contractor. I think all of us have always, as lawyers especially, looked at the documentation and felt it was insufficient. In terms of your experience with the tribunal, and you talked about sampling, which is, I would say, an art and a scientific approach. What have you seen typically with tribunals when they are looking at you as an expert to consider what's the minimum threshold of the nature of documentation as well as in terms of sampling? You're right, it's from a case-to-case basis. I'm not pegging you at a percentage, but when you consider it, what are the sort of minimum records that you would expect, and how should a contractor and employer also look at it?
Sure. I think that itself is a huge universe of, documentation itself is, we can spend one whole day just talking of what the perfect documentation is, but we do not tend to survive in a perfect world. What, in my experience, I've seen is that when one has to, in a very simplified fashion, be able to demonstrate the reasonableness, accuracy, completeness of the claim, which one has quantified, it is critical that you pick up very simple and logical documentation. I would say, whether you work back or let's say, you tend to work forward, you have to start, let's say, from the log sheets, etc. Let's say for the deployment of equipment, for the deployment of the manpower. The BOQ sheets, which actually tend to demonstrate that, let's say, if there was a certain budgeted BOQ quantities for certain material and how it actually spanned out on the project, you have to basically commence from the documentation, which is holding the logic of the technical design as well as the budgetary construct of what aimed to have been done and what has been done. From log sheets, one will logically go into invoices, etc. On certain other aspects, documentation, certain documentation, like let's say if one is just looking at the finance costing, then very, very simplistic sort of measures to say that have you benchmark, the rate of interest which is getting paid to the lenders with what's available in, very authenticated sources like the risk-free rates, etc. What has been the prevailing lender rates. And if one has to go into what is the kind of how you have apportioned, a lot of times what happens is documentation will be again for direct cost, because direct cost speaks for itself And you have to look for what are the right cues you need to pick by way of evidence, whether it is, let's say, log sheets and linking it up to, what cost you incurred, booked and paid, etc. But there is a lot of apportioned cost. Now, a lot of times, people tend to think that there is no way how we can justify a portion cost. Whereas, if you see that every project has a certain sanctity, if you're looking at a very large project company, so there has to be some scientific, logical basis to say that, look, if we did not take a loan for this particular project, but maybe, the corporate offices took loan for the entire business as a whole, then maybe what is this project constituting as, the overall revenues or et cetera, whatever is the parameters which the management may want to take. So I think whether it is justifying records or documents, evidences which are physical, then I think the quantification claim needs to be explicitly clear on what linked documentation you have relied upon. When it comes to mathematically derived claims, there the rational logic and industry benchmarks are most helpful.
Right. Thank you. As I think Ratan sir was mentioning in the morning, the importance of the SCL protocol comes into play for these sort of things. And you were talking about the records. I think one of the basic things I always tell a lot of the clients is, just look at the SCL protocol. There are certain set of minimal records which are mentioned in Annexure B. Do we have that covered? If so, at least we are in a good place. That's a good starting point.
Absolutely.
And then take it forward from there.
That's actually a very, very, very valid point, Alok, you brought in, because many a times, we are by clients asked to say, is there some sort of a checklist? And, we kind of drive them back to the SCL protocols and, these kind of benchmarks that exist, because there is no perfect what is a checklist. So I think these protocols come in very handy, definitely.
Yeah. I'll just deviate from the norm. David, in terms of in the Middle East, do you see documentation records being also an issue, or is it something which is, I'm sorry I'm putting you on the spot over here, but...
No, I'm happy to field this one. Yes, it is an issue. No matter how many documents you have, you'll always get claims which are put in a way that is less robust than they otherwise might be. And that can be because, a contractor who's suffering on a project is cash constrained potentially and doesn't have the resource to devote to developing its claims. But sometimes that can just be penny wise, pound foolish. And having someone in to develop those claims, draw out the material from the relevant project team, can be really valuable, because it adds its weight in terms of, or adds value in terms of, an early resolution of the claims. And to Professor Venkat's point, with his really clear presentation about global claims in particular, the attraction is always there for a contractor team to say, well, it's a global claim and you have that possibility of doing so. It's not, prohibited by law, so I'm going to advance it in that way. But the real risk in that is that it's an all or nothing claim. By its nature, you can't present an alternative, more detailed, nuanced valuation. And the problem then becomes, if there's no countervailing valuation and you go into an arbitration on that basis, the arbitrator is really bound to either give you what you want, or if the defendant presents a compelling case, give you nothing. The arbitrator isn't going to be in a position to come up with its own valuation for your global claim, because if the arbitrator or the arbitrators do that, they run the risk of a procedural irregularity and their award could be set aside. And we've seen examples of awards by respected arbitrators getting set aside because they went out on a limb in terms of trying to rehabilitate the quantification of a claim. So I think that's always a risk. And I'd say, as I say to my children, to contractors thinking about global claims, just because you could doesn't mean you should.
Thanks. Just a last question for both you and Geetu again. First to Geetu. And before it becomes controversial and I turn it towards the audience, the Hudson formula. Do you still use it?
Well, if you want me to give you a very honest answer, yes, I do. There are situations where I do have a hard time defending why I chose Hudson versus the other formulas. But I think in the Indian situation, typically, let's say I'm handling an Indian claim. I think the kind of evidences that you can put forth, the kind of, that whole philosophy of apportionment that a Hudson formula encourages you to take I think it's very solid in an Indian environment, and the kind of mathematically you kind of justify, and the kind of documentation, let's say an auditor certificate on, what's the kind of revenue the business is sort of, doing, the project is doing over the overall business, etc. So yes, I mean, I'm sure that, a lot of the audiences will not agree with me. But as a quantum expert, I can tell you that there are still several matters where I still believe that the Hudson formula stands out to be the strongest.
David, and then after that, Professor Venkat.
Well, there's a reason I'm a lawyer, not an investment banker or a quantum expert. I'll defer to Gitu as the expert on that for now. But one thing I will just in the little time available, point out is Gitu's reference to sampling earlier. I was delighted to hear about that because that is a massive issue, and it's handled very differently depending on who you're in front of and who's advancing the sampling. And that's not just fact specific, it goes to fundamental issues of methodology. You see the UK courts, for example, take a very different approach and less robust, arguably, approach than the US courts, who are more scientific in their approach. And so I just take this opportunity as a recommendation or suggestion that a future iteration of the SCL protocol have an annex that talk about sampling. I think that would be helpful.
Yeah. If at all you want to use a formula, don't use Hudson, use Emden. That's little more refined compared to the Hudson. And second thing is, for a head office overheads, our experience, the tribunals accept it, because we had a situation where we need to prove, in fact, it was a public limited company, it was in a Gulf thing, but it was a public limited company. We were able to prove that what is the operating expenses of the company, and we were able to extrapolate and show that for that project, how much it would be. When it comes to loss of profit, as long as it is not a remote claim, sometimes they look at it. Profitability may not be, but if the project is terminated, if I have continued, I would have made that profit. That for that purpose, there is a limited use where you need to prove that there is no other way to prove. I need to use a formula. Then I think more than the Hudson, Emden would be the better option, in my opinion.
I think the controversy has already started, but rather than take questions from the audience, we thought we'll flip it around, and we would, invite your thoughts. Obviously, we don't have the time right now to have a discussion with the panel, but just a parting thought for all of you out there. Some of you would have been aware of the recent decisions of the Supreme Court in Unibros as well as Bartley Boy Engineer, which sort of has overturned the entire way we used to look at Hudson formula and the other formula, Emden, or actually back when you used to consider the case of McDermott Standard Burns. Looking at how the Supreme Court is now considering these formulae and the use thereof, they're not criticizing it entirely, but they're putting certain stringent parameters. One of the most important parameters, and this is something you can start debating amongst yourselves, is that when it comes to the application of these formulae, the court says, especially for loss of opportunity, that you have to show the following. One, that you've not obviously underquoted for the tender. Second, that you would have actually profited if not for all of these scenarios. But most importantly, how do you prove that? They say that you have to demonstrate as a contractor that there were other tenders that you could have bid for, which is fairly easy. Most importantly, they say that you have to show that you applied for those tenders and were disqualified thereafter. Is that really something a contractor would do? A prudent contractor, consider the fact that if your balance sheet is already over-leveraged, would you actually go out into the market, bid for tenders, get disqualified, earn yourself a bad reputation, and then just to show that, look, therefore, there is a loss of opportunity here. So I leave that as a parting thought to all of you. You can debate. I'm sure there are employers here as well. Pardon me for that. I happen to be a contractor's lawyer most of the times. But thank you, everyone, for your patient hearing, and thank you for my panelists as well. Perhaps in terms of the questions, I think the panelists will be intermingling amongst you, so you can always ask them over there. Thank you so much, David. Thank you, Gitu. Thank you, Professor Venkat.
Thank you, Alok.
Thank you, Alok.
Alok, the last thing which you talked about, it has become a big issue for the industry in India. What Supreme Court said was existing in other jurisdictions, particularly in UK, Midwest judgment, old judgment of UK. Protocol talks about this. It says that you must have lost the opportunity. All of this is fine, and as you rightly said, proving it is not that difficult. Problem is how professionally documentation is done at the contractor's end is the key. How you budget every year for the projects, how you plan every year for the projects, and whether you had opportunity or not, what were the deliberations, in-house deliberations for the available opportunities, what were the regions for which that opportunity was not availed. This judgment will really make the industry, particularly the contractors, to better their documentation and record keeping for sure. I agree with you, Alok, so far as the last thing is concerned. You must have had applied for that. You must have had given the bid and then got yourself disqualified. Has its flip side also. No contractor wants to go and bid. And why will he bid in first place if he doesn't have resources at hands? And if he does that and gets himself disqualified, it is a bad thing happening in their records itself. So last thing is something someday will be raised before Supreme Court, and probably Supreme Court will take care of this.
Thank you so much, sir. Thank you, everyone.
Thank you, panelists, for a very, very interesting session. I would now request Mr. Hamish Lal to kindly felicitate the speakers.